Hello, it's Hermie Abraham from Advocation Employment Law, and I wanted to jump on a quick video today to follow up on our Tuesday Did You Know post. And in that post, we talked about workplace harassment. And we did get a number of comments about that, and I had a few consultations this week that dealt with workplace harassment. So I wanted to jump on a quick video just to discuss and dispel a couple of myths that persist about workplace harassment that will hopefully be helpful to you. So the first is what we posted on Tuesday, and that is that the intention of the person who's alleged to have engaged in harassment or discrimination or bullying does not necessarily matter. And that's because if you look at the legal definitions for harassment, for workplace discrimination, you'll see that it talks about conduct that is unwelcome or unwanted, and it's a reasonable standard, so it's reasonably unwelcome or unwanted. And what that means is that it's not necessarily what I felt in my heart. If I'm the accused or the alleged person who engaged in this misconduct, it doesn't matter what I felt in my heart or what I was intending to do. What ultimately matters is how it was received, if it was unwelcome. And so if I'm telling an off-color joke and I think it's funny, somebody else might feel that it's actually, sexist or racist. That would be the litmus test. If they felt reasonably that joke that I was making was sexist and racist, I could be in breach of harassment or discrimination policies within the workplace and generally at law, if you look under the Human Rights Code. So that's the first thing, that intention doesn't matter. The second is with respects to a person who is making a complaint about harassment. So oftentimes people want to make a complaint, they want to tell HR or their supervisor or maybe a friend about something that's happening in the workplace, but they don't necessarily want it to go much further, or they don't want it to be, blown out of proportion. And the fact is that when an employer comes to find out about harassment in the workplace, in some circumstances, and this is true especially with workplace sexual harassment, there is a legal obligation for the employer to investigate the allegation. And that means the employer has to have an investigator who's appointed. That can be somebody either internal or external. And that person has to meet with everybody who might be involved or have evidence and figure out, get to the truth of what happened. And sometimes people feel that that's unnecessary. They don't want that, especially if they're the complainant and they want to just basically put it behind them. But they have to understand that if you're in this situation, you have to understand that your employer has a legal obligation under the Occupational Health and Safety Act because harassment in the workplace is being treated no different than any other workplace accident, right? So if there was a workplace accident in which there was an injury, the employer would have obligations under Occupational Health and Safety Act as they do when it comes to workplace harassment. So that's the second thing. The third is with respects to investigations themselves. And oftentimes people who are party to investigations, they feel or they're worried that, the investigation is not fair or it's impartial. And understand that when your employer is conducting a workplace investigation, they are a neutral third party. They're really looking to get to the fact of what happened. You might not see them as neutral, and maybe they don't want to know that the harassment happened, but they're really just there to get to the fact of what happened. They're not your adversary, but they're also not your advocate. And so for that reason, if you are party to an investigation, especially if you're the complainant or more specifically the respondent, it helps to be able to speak to someone who can advise you, who can be your advocate through the process. Some unionized employees can work with a union member. Understand that union member might not have legal training. And so it's always good to be able to speak to somebody at law who has legal training, who can be able to advise you, who can be able to help you with your witness testimony. And that's especially true for respondents when your reputation might be at stake and a finding could be very damaging to you, or you could risk losing your job, or even worse, that there might be criminal charges that would attach to your actions because you've done something that also breaches a criminal code, like theft or something else. So if there's a workplace investigation and you stand to risk a lot, it's always worth spending the time to speak to someone so you're clear about your evidence, how you should present it, what the investigation process is all about, so you're not going into it cold or blind. So that's what I wanted to share with you today. I hope you found it helpful. If you have any other questions or if you need assistance with respects to a harassment complaint or a discrimination complaint or any other workplace issue, definitely please do contact us. We'll leave our contact information in the caption description above or below, and we look forward to helping you. Take care. Goodbye.